And I rise to speak as the chairman of the Committee of Health and Children, and I want to first of all pay tribute to the Minister for her stewardship in the department and for her publication of the bill which we're discussing today. And to be generous to the Minister, I think Deputy Halligan is being an understatement, because this Minister, as you rightly say, does listen, does take advice, and one of the first things she did as a Minister was to refer the Children's First Bill to the Committee of Health and Children for pre-legislative scrutiny, one of the first pieces of legislation that we had to do. And in my hand I have the tome of our hearings which represented the Minister. And I suppose, Minister, my remarks today are going to be about the pre-legislative hearing and about what we've done as a committee in this context, but I also would like to come back at a later time to discuss my own observations and points on the bill, and in particular to address some of the issues. The purpose of the Children's First Bill is to put children first, a national guidance for the protection and welfare of children on a statutory basis, which is a key commitment in the programme for government. In April of 2012, the Minister for Children and Youth Affairs, Frances Fitzgerald, referred, as I said earlier, the heads of the bill to the Committee of Health and Children. The committee, over a 2-month period, undertook an extensive consultation and consultative process by engaging with many key stakeholders through receiving written submissions and holding public hearings. And in the report that we have presented to the House and laid before the House as you act us, you can see from the different groups that came in, be it in education, be it in childcare, be it professionals, there was a very extensive range of communication. 58 submissions were received, including oral submissions, on the bill from state agencies, from voluntary organisations, from professional bodies, members of the public. And I want to, at this point, as I've done in the past, thank everybody who made a contribution to our work, who took time to write or to participate in public hearings. Because between the 1st of May and the 30th of June 2012, the committee met 8 times to hear in its public consultative process submissions in an oral presentations and discuss the heads of the bill with stakeholders. We met a total of 29 groups with a total of 47 witnesses. And again, I think it's important that we put in the context of this House, last Council, that the work of the committee provides a platform for members of the House and for outside groups and agencies and professionals to come and assist and participate. And I contrast that with what happened in the past in departments, where you saw, and you actually didn't see, is the point I really want to make, the writing of legislation being moved from civil servant in Department A to Department B, in Section A to Section B and back. But now we have it done publicly in a manner that is visual, that is participative, and that involves and gives ownership to many different people. And I think the overview of contributions assisted the Minister and the Department in that consultative process. I think it is worth recounting, Last Council, the background to this bill and to highlight how long it has taken us to put in place a statutory basis for the protection of children. And I think it's important that we acknowledge that this is a Minister who in the first half of her term of government has done that, has acted. Rhetoric in many cases was easy. Language we can all use at different points to promulgate and to advocate or to deny or procrastinate, but this Minister acted. And when I heard Deputy Troy yesterday, I said, you know, and I don't mean to be political, but we saw, you know, an opportunity in their window of government that wasn't acted upon. But in saying that, in 1999 we had the Department of Health introducing Children First, the National Guidelines for the Protection and Welfare of Children. These were produced, as we all know quite well, to assist the identification and reporting of child abuse and to improve professional practice in state and voluntary agencies, which allows for the support of of the children and the families, as Deputy Halligan rightly mentioned in his remarks earlier, in terms of out of hours in particular. The Children First guidelines identify the duty to report abuse as a societal one that is owed not just by social and medical workers, but by all who work with children, including An Garda Síochána, HSE personnel, those working in public agencies, voluntary community organisations, and all of us as individual citizens. And I think that point is about all of us has a duty and have a role to play, and we should never forget that. It's also important to outline that the guidelines provide guidance on identifying physical, sexual and emotional abuse and neglect, on when and how to report the issue and the procedures for assessing and managing the cases, along with setting out the roles of agencies such as the Gardaí, the HSE, school and medical professional personnel, along with providing for participation at a local and a regional level in terms of the creation of child protection committees and outline procedures for cooperation between the HSE and Gardaí as the two agencies with statutory responsibility for child protection. And the guidelines also stress the importance of family support services as a means of mitigating risks to children. The implementation, Lasca Corla, and operation of the Children First guidelines were reviewed several times during those 3 years, or during those years after their introduction by the Office of the Minister for Children and Youth Affairs in 2008, and it resulted in a number of revisions to the guidelines which were published in 2011. And the revisions took account of, among other matters, the recommendations in the report of the Commission to inquire into child abuse, which is the Ryan report, and we all remember when that was published, and the need for action as a consequence of that. And one of the recommendations arising from that was the Children First guidelines will be placed on a statutory footing. And the main objective of the Children First and National Guidance for the Protection and Welfare of Children to establish a firm foundation, is to establish a firm foundation from which practitioners can develop a uniformity and a consistency in the application of these national guidance throughout the state, something that we all need to see and continue to see happening, and we welcome that fact that is happening. I think in the context of the work of the committee last Corla, it was clear from our hearings that we need to foster a culture of understanding and compliance. The creation of an office at cabinet level of a Minister for Children has helped, in my opinion, no end. It has given this Minister an authenticity that perhaps others may not have had, and I don't want to be derogatory to other previous ministers who did quite well in their position that we had, but this Minister sits at the cabinet table and gives her that opportunity to not be a junior, but to be seen as equal to other cabinet colleagues. And that's important in the context of this department. The Children's First Bill is about aligning the law with what is right. It is about bringing an end to any remaining attitudes that may choose to ignore child abuse and neglect. And it can no longer be an option, Lasca Corla, to have child protection put, to one side. We must put child protection as a priority. Compliance with Children First must be mandatory and can't be voluntary. For the Children First legislation to be effective, we embarked as a committee on an open dialogue with those groups who will be working with this legislation on a daily basis. The process undertaken by the committee undertook to give key stakeholders an opportunity to contribute in a meaningful way to the formulation of this legislation. And I want to, at this juncture, say that the people who participated did so in a very holistic way, and were not afraid to make comments and didn't hold back on their remarks and their comments regarding the heads of the bill. And I'll come to that later on. As I said earlier, Lasca Corla, as part of the process, we held a series of public hearings with advocacy and representative groups, with government departments and voluntary organisations working in the areas of sports, in youth activities. We also met with key lead personnel in child protection, in child law, in children and family services, in education. And by giving these groups the opportunity to contribute, it enabled their practical day-to-day experience to inform the legislative process, something, as I alluded to earlier, we've done quite significantly in this Dáil. And I think the committee system is benefiting from legislation coming to it for pre-legislative scrutiny, not in an adversarial way. And I want to pay tribute to people like Deputy McClellan, who's in the chamber, and Deputy O'Quailon, and Deputy Keller, and Deputy Troy, and Senator Van Turnhout, and members of the Fine Gael Labour Party, who go into committee and give of their time to pass and go through legislation and engage with people for the betterment of society and to make the legislation more complex, more comprehensive than perhaps it came into us. And I think, you know, if people were to read the full transcript of the hearings, they will see that in the outlining the views of the stakeholders and the views of members of the committee, you will see that there was a genuine participation and that the children and the child was at the centre of what people were speaking about. And I think it is in the interest of all of us in society and of all children and parents that Children First legislation is practical and is effective, and it must deliver a reformed child protection regime. And I would hope that the Minister, as part of this debate today and this week, will take on view some of the views expressed by all of us in the House. We must protect children by making sure that their concerns are acted upon and not ignored. And I speak, Lascian Corla, as a school teacher of 20 years' experience, as somebody involved with Common Lou Class Gael, as someone who was involved in my community, where the issue of child protection and the way in which we deal with young people has evolved to a more professional, more thorough way than what it was. And thankfully, the child is at the centre. The observations and recommendations in this report of the committee were intended and are intended to inform and guide the drawing up of the Children First legislation. The committee members welcomed the opportunity to engage at a very early stage in shaping and in flagging issues in the legislation before it came back to the Dáil and the Seanad. And I think it is important at this juncture, as the chairman of the committee, Lascian Corla, that I record my appreciation and those of my colleagues to the many different interest groups who did make submissions to the committee in its preparation of the report. And I want to also, as I said earlier again, and do so because I think it is important that we highlight the importance of the members of the committee for their invaluable work and their commitment and dedication to the important body of work. And equally, it is important in the case of this piece of legislation and in the case of our massive tome that we put on record, and I put on record, that we acknowledge the contribution of Mr Michael Sullivan, who was engaged by the committee in a professional capacity to assist as our rapporteur in writing and compiling the report with the committee, and also to thank the committee and the staff of the committee secretariat of the House of Directors of the Children and Health Committee for their assistance in the report being compiled. In speaking next on the overview of the contributions made to the committee, I do think it is equally important that the following piece of my speech is given to a synopsis of the main arguments and observations made in submissions and presentations to the committee on the Children's First heads of bill. And I do so, Lascian Corla, in the backdrop that we can see where the Minister has listened and choose to act, and where she has listened and choose not to take on board perhaps some of the views of the committee, which is fair enough too. And perhaps as part of our discourse, you know, we may be able to see are there other issues that the Minister may look at again. But under the general scheme of the bill, nearly all contributors welcomed the proposal to give the Children First guidelines a statutory underpinning in the bill. A common observation was that giving effect to the bill, particularly in the early stages of its implementation, would require substantial investment in resources, including the training of personnel, the recruitment of personnel, and offering support and feedback. And many contributors made the point that they said it was of particular importance that the bill should be drafted so as to mesh seamlessly with the provisions of the Withholding of Information Bill and the National Vetting Bill. And several contributors said that the bill made insufficient allowance for the voice of the child to be heard, as mandated by the UN Convention on the Rights of the Child. Other contributors criticised the general scheme of the bill as misguided, saying that its focus on reporting missed the principal causes of failure in child protection. And these contributors generally felt that the bill should place greater emphasis on family supports, early intervention, multidisciplinary assessments and the coordination between all relevant agencies and government bodies. Another criticism that was mentioned in terms of the general scheme was that the requirement to report concerns or suspicions of abuse together with criminal sanctions for failing to do so would cause defensive over-reporting, placing undue burdens on organisations, possibly overwhelming the state's child protection services and diverting resources from support and intervention services. And several contributors said and stated that it was particularly important for the implementation and operation of the bill to be reviewed after no more than 3 to 5 years. If I could be specific, Lascian Corla, in moving to Head 2 interpretation, a majority of contributors argued that the definition of child abuse should include emotional abuse, and that was a very significant amount of people, and the reasons for doing so included the long-term effects of emotional abuse, its relatedness to grooming, physical and sexual abuse, and many pointed out the emotional abuse is included in the Children First guidelines and suggested that its exclusion from the bill would cause confusion and inconsistency in enforcement. And the Minister should be complimented on the way in which she has handled the issue of grooming and the way in which she has been to the fore in protecting the rights of the child in this case. In its presentation, the Department of Children and Youth Affairs did argue at the committee last year that the exclusion reflected international evidence on the difficulty in reliably diagnosing emotional abuse to a standard that would support and could support criminal prosecution. And emotional abuse could still be reported under the guidelines, and its exclusion from the bill related only to criminal sanctions for failure to report abuse. The Department did say that they were open to this matter being revised and to revision, and similarly it was suggested that the definition of physical abuse was inconsistent with that included in the Children First guidelines. The Irish Medical Organisation felt that the definitions of abuse in the bill needed to be much clearer if doctors were to have confidence of diagnosing abuse to a standard suitable for judicial proceedings, and it was suggested at committee that the exclusion of married persons aged under 18 from the definition of child was not appropriate, and several contributors advocated greater clarity in the definition of concern, not only because of the possible criminal sanctions contained in the bill, but also to assist effective reporting without overwhelming organisations or the child protection system. And that was a very strong point last Concora, where members were genuinely, and people participating were worried about the overwhelmingness that could arise from the bill. But it was also suggested that the definition should extend to suspicions that a child is at risk of abuse rather than simply that of being a child is being abused. And it was pointed out that the definition of employment was inconsistent with that in the vetting bill, and in this discrepancy should be remedied. It was also suggested that including unpaid positions such as internships in employment while volunteers had different responsibilities was anomalous. Many contributors expressed concern about the definition of sexual abuse itself. These mainly centred on the lack of clarity as to when peer sexual activity between teenagers is or is not consensual in the eyes of the law. A number of contributors pointed out to discrepancies between the language of the bill and that in existing statute of law and the withholding of information bill. There was general but not unanimous support for the views that the bill should not require reporting of consensual peer sexual activity between teenagers, as it was felt that this would inhibit recourse to sexual health and advice services that seek to reduce teenage pregnancies and underage sexual activity and to promote sexual health. Several contributors suggested that the definition of volunteer was too broad and that it should not include, for example, parents who volunteer on an ad hoc basis to drive children to a sports fixture or school outing, and the definition in the bill refers or differs from that in the Children First guidelines, which at the time was believed would cause confusion. If I could just turn last Concord to Head 5 in the context of aims and principles, several contributors referred and suggested that the reference in Head 5.1 to the welfare and protection of the child should be changed to the best interests of the child so as to reflect the UN Convention on the Right of the Child. And there was wide support for the requirement to have due regard to Children First guidelines. However, several contributors did make the point and argued that the duty to report should be extended to all state agencies, to all persons having access to children, or even to all persons regardless of their status. A number of contributors suggested that the Children First guidelines, as well as other guidance documents provided for in the bill, should be all given statutory effects as regulations made under the bill rather than as non-statutory guidance documents. The relationships of the guidance to the bill was problematic for some contributors, who pointed out the difficulty of reconciling definitions, roles and responsibilities under them. In the context of Head 6, dealing with organisations with a statutory obligation to report child abuse, the types of organisations included or excluded from the bill's operation was the subject of much discussion. Many contributors objected to the exclusion in Head 6.3 of services paid directly by a child's parents or in the child's own home, for example, that of a childminder, while many accepted that organisational requirements of the bill would be inappropriate in such settings, and the duty to report should apply, as should the requirement for training and familiarity with relevant guidelines. And similarly, it was suggested that bodies such as agencies that supply minders, au pairs or nannies should come within the terms of the bill. There was wide support for the view that the exemption should not cover any paid arrangement for minding children, particularly when this takes place in the children's home, or in the minder's home rather, I beg your pardon. The presumption that parents provide the best supervision for their children was in some cases criticised with being inconsistent with the fact that the majority of abuse does take place within the child's own home. The exclusion of leisure facilities, particularly swimming pools, that cater for adults but allow access to children was criticised by a number of contributors. Similarly, services such as domestic violence shelters, third-level institutions, particularly those that arrange placements involving the care of children and asylum-seeking centres, should be expressly brought within the bill's operation. And others argue that the employers of children should be covered by the bill. Under the context of Head 7 organisations, the committee heard many different viewpoints, with some stating that the detailed requirement for organisations was onerous and would pose difficulties, especially for smaller or voluntary bodies, and the view was expressed and felt that those requirements should be phased in over time to allow for these organisations to which they applied to cope and to put in place good governance structures. There was also a widespread view that the safeguarding guidance for organisations and model keeping children safe plans should be published and open to comment by stakeholders before the bill became law. A number of contributors made the point and felt that these documents should be merged so as to reduce the number of reference documents that organisations must use. And several suggested that the safeguarding guidance for organisations should, along with the guidelines for the reporting of abuse, be issued as statutory regulations. The need for resources and training from the HSE was stressed by many contributors, as well as the need for suitable, and I quote, train the trainer, unquote, courses that could be used to develop training within organisations. A number of contributors offered to provide training based on their area of expertise. Many contributors argued that the vetting requirements under this bill should be reviewed to ensure consistency with the vetting bill. And the teachers' unions points out to us that schools operate a number of policies and procedures to implement the Children First guidelines, and that the bill should include and take account of and seek to accommodate the existing arrangements so as to minimise duplication, disruption and confusion. The requirement for internal audit raised a number of questions, with many arguing that the external experts should be allowed onto the relevant committee, and that the national bodies such as sporting organisations queried whether internal audit should be the responsibility of each affiliated body or club, and argued that it would be better to leave responsibility at the level of the umbrella body. It was also pointed out that the requirement for designated officers to appoint internal audits was inconsistent with the way in which schools are organised, and that the bill should accommodate the appointment by structures such as boards of management. Under the heading of Head 8, which deals with the notification of HSE by organisations, the timeframes for notifying the HSE was found by many contributors to be very tight, and the requirement to maintain records onerous, particularly for small organisations, and support for the HSE was suggested as a way and a means of overcoming these difficulties. And that was a recurring theme last Concordia, was that of the smaller organisation being able to cope with the demands being placed upon them, and the need for training and support for them. In addition to that, several contributors did make the point that an extensive publicity campaign would be necessary to ensure that both organisations and the public of the need for registration was essential and was fulfilled, and one contributor suggested making failure to register a summary offence. Several contributions were made in the context of outlining and pointing to the importance of maintaining consistency with and avoiding duplication of provisions of the Childcare Act 1991, 2006 Preschool Regulation and the Vetting Bill. There was, at the time, uncertainty about the registration requirements of national organisations and their affiliated bodies, and whether all or such were going to be subjected to provisions, including record keeping, as detailed in the head, which was Head 8. The issue of the designated officer in organisations was one that was mentioned, and there was a universality in welcoming the role of the designated officer to help ensure accountability and responsibility for child protection. This was seen as necessary, but equally, Lascia Corla, it was also and is seen as a necessary means of filtering concerns so as to avoid over-reporting. However, there was a view expressed that by several contributors that the extensive functions and duties listed under the then Head 9 may prove too onerous for school principals or those, as I said earlier, involved in small voluntary organisations, which may result in potential volunteers being put off and being deterred. Several suggested that the focus of responsibility on the designated officer rather than the organisation itself was inappropriate. And I think it is important that even today, when we have the bill, that the role of the organisation and that the role of the designated person or designated officer is monitored, is understood and is communicated clearly. There still is and there was a widespread recognition for the need for training to be ongoing, and this was stressed right across our deliberations. Several contributors noted that the difference between the role of the designated officer in the bill and that of the designated liaison person under Children First guidelines, and they did suggest that this discrepancy be remedied in the bill. Equally, it was of the view that seniority alone was not sufficient for a person to be given the title of designated officer. Suitability and experience was essential, and I do think even today it is important that we highlight that fact, that the designated officer must be suitably qualified, must have that experience, and it's also important that the seniority criteria, even in schools, isn't necessarily suitable, and that where principals are answerable to boards of management, it is appropriate that there would be due notice given in terms of the way in which people are appointed. The designated officer's power to delegate was also made reference to by other contributors, and national governing bodies such as the sporting organisations suggest this cascade model where a national designated officer could have overall responsibility for the role, while designated liaison persons in local bodies such as clubs could be delegated powers accordingly. Some contributors suggested curbs on the powers to delegate to avoid the possibility of it being used to avoid essential functions. And I think it is important, Lascia Corla, that we pay tribute to our sporting organisations who have put in place a very robust child protection structure. And that is something we should put on the record. And I know from my own case, being involved in Common Class Scale, it is something that the GA is very vigilant on, and the people in Croke Park and at council level, in the provinces and at county board level and at club level should be commended for. And it's something that I think, we don't see perhaps the work being done, but in lots of cases it's done quietly and it's done without any fuss. And again, the child is at the core of what we do here. I suppose the other point that we should use in terms of the issue of safeguarding, the safeguarding guidelines, is that there was a consensus that these guidelines for organisations and the guidance of reporting of abuse would be published before the bill took effect, and that there would be cooperation and assistance by the HSE with investigations, and that there would be proper communication. Other contributors suggest that the HSE should develop standard protocols for reporting based on current ones and make them available online. There was a view, and I know I'm short for time, Lascia Corla, that employees and volunteers should be examined carefully to ensure consistency with the Withholding of Information Act the 1988 Act and 2011 Department of Skills procedures and the new proposed guidelines for the reporting of abuse. And some contributors did suggest that